My name is Patrick McCabe. I live in Hyde Park, Massachusetts, and I'm appearing here before you with the Fatherhood Coalition, as we often do, to raise our concerns with custody decisions and restraining orders that come out of our courts. I just want to clarify something that's been said in the past. We do come here because actually we feel welcome and we feel we're part of the process, but that's not the only thing we do. We do work with our legislatures to get things resolved that way. And although I'm very critical of the family court, I would like to say that we have reached out to Justice Perry, and we have reached out to Justice Perry, and we have made it. I've been doing this for a long time, long before I knew of the Fatherhood Coalition, and I do want to go on record as saying Justice Perry has been more receptive than her predecessor. We're doing everything we can, reaching out to everybody we can, trying to work together to improve a situation I think that just doesn't work for the people of Massachusetts. The reason we're speaking here today is because of our concerns about custody decisions that are made in the family court. According to the records that we're aware of, 90% of the cases end in sole physical custody. And we're concerned about the role that our justices play. But I'd like to raise another issue that I think the judiciary needs to be aware of. In our advocacy role, we often go to court and we meet people or we go to court with people. And we're seeing a practice where the bar, lawyers, are actually misrepresenting to their clients what's going to happen in court. They're getting their clients to agree to sign agreements that are not in their interests and that their clients simply don't understand. And in the interest of justice, I think the judiciary needs to be aware of this. And we would like to know if this nominee is aware that there should be concerns. Often, when people appear before a judge, judges raise questions about agreements that are signed to make sure everybody understands what is being signed. Again, when it comes to custody, when people are giving up custody, I don't think that's a natural thing to do. And we'd like to know what this nominee's opinion is of what are you going to do when people come up and they're for some reason giving up custody of their child and there doesn't appear to be any reason. Are they going to question that? Are they going to make sure that's in the best interest of the child? We're very concerned about what's going on with custody decisions. We'd like to see more work done on it. We're also concerned about with the inappropriate restraining orders. The basis for a restraining order is reasonable fear of serious, imminent physical harm. Again, we're seeing in the probate court that restraining orders are often used as a negotiation tool. We don't believe this is appropriate, and we actually think it looks pretty bad when, as part of the negotiation, it's clear that it was used that way. And we'd like to know the nominee's positions on these two issues. We've written to her. She's responded back that she thanks us for our concerns, but she has not answered any questions that we put forth to her. Joe sent the questionnaire that the Fatherhood Coalition has. I just asked two open-ended questions. What do you think of the custody decisions in light of the shared physical custody, and what do you think of the restraining order? In neither case did she take the time to answer. She has told us that if you put any questions to her, she'd be more than happy to answer your questions.
Did she give you any indication in her correspondence about her thoughts about any issues related to some of those concerns? Did she elaborate at all?
No, but she said she would to you.
Okay. Any comments, any questions?
No, thank you.
Thank you very much.
Appreciate it.
All right, so you're up.
Thank you.